What should you do if you're arrested for speeding in South Africa? In the previous video, we talked about whether you can be arrested for speeding in South Africa. And in short, the answer was that our courts have found that although speeding can be a criminal offense, it does not automatically justify an arrest. But just because an arrest for speeding under most circumstances would be considered unlawful, that won't necessarily stop the police officer or traffic officer from arresting you. So what do you do if you find yourself on the side of the road, pulled over by a traffic officer for speeding, and that officer informs you that you're going to be arrested? What should you say? Should you say anything? Should you sign anything? Can you get bail? And what actually happens in court? That's what we'll be discussing in this video. Hi, my name is Ethan Roets. I'm the director of Roets Attorneys Incorporated, and I'm a practicing attorney in South Africa. This video is not legal advice. It is purely meant for information purposes and to increase discussion around South African law and the South African legal process. If you are arrested for speeding or anything else, you're welcome to contact us and we will assist you. Or if you have your own attorney, you can consult with them. Now, with that being said, let's get back to the video. The first mistake that people make when they're arrested for speeding is trying to argue their defense on the side of the road. Do not do that. Do not argue with the officer. Do not threaten or insult the officer. Do not attempt to resist arrest, and please do not attempt to flee the scene. So often when we as attorneys have to go to a police station to attempt to get a client out on bail, we have to deal with several additional problems that the client has caused themselves during the actual arrest process. This will only make it more difficult for you to get out of bail and might make your case more difficult in court. If you believe that you are being unlawfully arrested, the time to fight that battle is subsequently in court, not on the side of the road. So the very first thing that you do when you're arrested for speeding, or when the officer informs you that you're going to be arrested for speeding, is remain calm. The second thing that you should do if you're arrested for speeding is ask the following questions. Am I being arrested? You want to confirm that you are in fact being arrested. What am I being arrested for? So that you can get the actual offense that you're being charged with to inform your attorney. Which police station am I being taken to? So that if your attorney or family members try to apply for your bail, they know which police station you're being held at. And can I make a phone call to my family members or to my attorney? If you have an attorney, call your attorney immediately. If not, call your family members and inform them to call your attorney. I will put our details in the description below. If you require any assistance after having been arrested, you can contact us. Again, it's important to remain calm. Ask the questions calmly and take note of the answers, and as best as you can under the stress of the situation, remember this information. The goal right now is not to start or win an argument with the police. The goal is to understand what is happening and get the proper legal assistance. Another big mistake that people make when they're arrested is they start talking way too much and saying way too much. They panic, they try to explain the situation, they admit guilt, they try to negotiate with the officer, and even worse, they try to offer the arresting officer some cool drink money to make the situation go away. Do not do these things, especially the last one. You should provide the arresting officer with your identification and the details that they need to process you. You should comply with all the lawful requests from the police officer, but do not make any admissions at this point. Remember, in South African law, you have the right to remain silent. Exercise this right wisely. That doesn't mean that you should be rude or sarcastic to the officers, and it doesn't mean you should become non-compliant. It simply means that you have the right in the moment to remain silent so that you do not make a statement that will hinder your defense later on. Just remember this simple sentence that can protect you. I want to speak to my attorney before making a statement. And this sentence remains important throughout the process in the police station as well, because it is at the police station where they will actually ask you to make a formal statement. Once you arrived at the police station after being arrested for speeding, the immediate practical issue is usually to get you released. As I've stated in the previous video, the offense for exceeding the speed limit is generally not considered a serious offense, so bail shouldn't be a problem to obtain the same day. Again, assuming that you didn't do anything while you were arrested to add more offenses on top of the speeding, which will just cause you problems. Make peace with the fact that you are going to be held in the holding cells of the police station that you were transferred to. Do not argue or get into physical or verbal confrontation with the police about this. They are just doing their job. Your details will be taken, your fingerprints will be taken, and you will be processed. You want to be processed as soon as possible because we can't actually get you out on bail until you have been formally processed. Now, somewhere around this point, you will be given a document, which is the first document that you can actually sign. It is a document that conveys your constitutional rights to you. They give it to you to sign, not as an admission of anything, but to acknowledge that you have received the statement setting out your constitutional rights. It's important to read these rights. These are the basic human rights that you have even under detention, such as the right to a healthcare provider if you have been injured, or, of course, the right to see your attorney. If the police docket has been opened and you've been formally processed, now we can take a look at whether you can be released on what we call police bail. So police bail is exactly what it sounds like. It's bail that is granted by the police, and it is granted before your first appearance in court. You definitely want this to happen because this will avoid you spending the night in the holding cell. Or even worse, if you're arrested on a Friday or over the weekend, you're going to spend the weekend in the holding cells and only appear on Monday. So your attorney or your family member should try and confirm what charges you're being held for and whether bail will be considered by the police. Again, the offense for exceeding the speed limit is generally considered a lesser offense, and you shouldn't have any problems getting bail on the same day. But also, do not assume that you will automatically be released on bail. There is a chance that you will be held overnight. Depending on the circumstances, each case will be considered on its own merits. That is exactly why you should contact our offices or your own attorney. We'll be able to assist you through the situation, consider the circumstances, and give you the best chance of getting out on bail the same day. For bail, the important question is not whether you're guilty or not. This will not be considered. The important question is, can you be released on bail without being a flight risk, and whether you will impair the state's investigation of the crime. The more stable your personal circumstances are, the more likely it is that the police will grant you bail and will not consider you a flight risk who will not appear in court. Also, an important note from my experience, the amount of bail that you have to pay for these kinds of offenses range between 1,000 and 2,000 Rand. If bail has been granted and you're being released, great. Take note of the date and time that you have to appear in court and make sure that your attorney is aware of it and that you appear on the day. Remember, you are warned to appear by the police, and if you don't appear, you risk forfeiting your bail and a warrant of arrest being issued against you, and you will likely not be released on bail a second time. If bail is refused, again, just remain calm. You're going to have to tough it out through the night and appear in court the next day. There is no use in despairing over the situation. Remember that the South African Police Service have an obligation to protect your constitutional rights. So if anything occurs in the cells, like you get assaulted, you're refused meals, or you're refused other basic constitutional rights like healthcare, this can be used against the state in subsequent court proceedings. It all adds to the damages that you've suffered and escalates the amount that you'll be able to claim from the state under those circumstances. For your first appearance, if you haven't been released on bail and you're still in the holding cells, the police will transport you to the courthouse and you will be called by the court. No need to worry about that. If you have been released on bail, make sure you're at the right court in the right courtroom at the right time. People will tell you that first appearances are heard later in the afternoon. Generally, in most courts, I've found that to be true, but make sure that you're at court in the morning, normally 8:30. Also, as a general rule, if you've been released on bail, make sure you're dressed properly. You don't have to wear a full suit and tie like your attorney will, but no open-toed shoes or shorts. Depending on whether you've been released on bail or not, you will either be down in the holding cells or in the gallery of the court until your name is called by the prosecutor. The prosecutor is the representative of the state who will lead the state's case against you. When you appear for the first time, the magistrate will ask you whether you have legal representation. If you do, your attorney will stand up and take the matter from there. If not, the court will give you three options. Either you can represent yourself, you can use the legal aid attorney who's available to you free of charge, or you can get your own private attorney. I would highly recommend that if you can afford an attorney, get an attorney. If you cannot afford an attorney, apply for legal aid. But I would urge you strongly not to represent yourself. I appeared before a magistrate in the Randburg Magistrates Court who put it perfectly. If you have a tooth that bothers you, you go to a dentist. If you have a medical problem, you go to a doctor. If you have something that needs to be removed, you go to a surgeon. So if you have a legal issue, why on earth would you try and fix it yourself instead of going to a professional? If you have your own attorney, but your attorney is not present in court, the court will likely postpone your matter for your attorney to appear. This is not the best outcome if you're still in custody, because you will remain in custody until the next occasion where your attorney can appear. Instead, make sure that if you have your own attorney, your attorney is present in court on the date of your first appearance, or that you apply for legal aid. After representation has been sorted out, if you're still in custody, the next issue that you have to worry about is getting out on bail. Similar to the police, the court will now consider your personal circumstances. They will look at whether you're a flight risk and whether you are going to impede the state's investigations. On the other hand, they will look at things like your ties to the community, whether you have a family, dependents, whether you're currently employed. All of this will be considered by the court. Now that representation has been sorted and you're either out on bail or you have successfully applied to be released on bail, it's time to proceed with the matter. I want you to make peace with the fact that the criminal process takes long. This matter is more than likely going to be postponed several times because the wheel of justice does turn, but it turns slowly. Next, usually the state requests postponement to finalize their investigation. More than likely, they still want to make sure that you have no previous criminal convictions or pending matters against you. If the matter is postponed, that's fine. The court will confirm the date with you, warn you to appear, and extend your bail. And on that date, the same general rules apply. Dress appropriately, arrive on time at the correct court, and make sure your attorney is aware of the date if your attorney is not present in court. The next postponement will be requested from your attorney or requested postponement for a disclosure. What this means is that now that the state has finalized their investigations, they have to make a copy of their file and give those copies to your attorney. This will allow you to understand the case that is being made against you. It will have all of the records from when you were arrested, including the reports that were generated by the speed cameras and any statements that were made by the police. This is what your attorney will use to either defend your case or to make representations to the prosecutor, which is the next step. When your attorney has received a copy of the police docket, the next step is to postpone the matter to make representations to the senior prosecutor or to the control prosecutor. This is where your personal mitigating circumstances are put in a statement along with the circumstances of why you were speeding. And then a request is made to the court for the matter to either be withdrawn by the state completely or for the matter to be referred to a diversion program. Now, this is where the circumstances matter, like what speed is alleged. What device was used to measure the speed? Was the device used properly? What happened on the roadside? Was the arrest lawful? Were you actually the driver of the vehicle? Is the vehicle recorded on the docket the vehicle that you were actually driving? These will all determine what representations your attorney will make to court, either to withdraw the matter completely because the state has no case, or if the state has set out a proper case, to make representations for the matter to be referred to a diversion program. At this point, you may consider paying an admission of guilt fine, but be careful of this. It might seem that the problem will simply disappear, and in certain instances, it is the quickest way to finalize the matter. But if you've been arrested for the offense of exceeding the speed limit as it is set out in the Road Traffic Act, there could be some serious consequences to this. For example, you could end up with a criminal record and all of the consequences that will follow from that. And there are potential consequences for your driver's license. If you're a first-time offender, your driver's license could be suspended for 6 months. I generally advise my clients against this course of action, but it's important to get legal advice for your particular matter and your particular circumstances to decide which is the best option. Now let's talk about the diversion program. If your attorney has submitted representations for diversion to the senior state prosecutor or the control prosecutor, and those representations are successful, you will most likely be referred to the NICRO program. NICRO. You will then be taken to a social worker at the court who will ask you questions about your personal circumstances and determine whether you are eligible for the NICRO program. The NICRO program is essentially a safe driving course. They have several courses on several different topics, but in this case, we're referring specifically to their safe driving courses. This is a court-mandated course that takes place over several weeks, normally virtually, although there are some physical attendances that you have to do. And at the end of it, you get a certificate that says that you've completed the NICRO program, you've been rehabilitated in essence, and that you are aware of the rules of the road and the consequences of breaching those rules. If the social worker agrees for you to be referred to the NICRO program, the court will postpone the matter for you to attend that program and to hand in a completion certificate afterwards. You will then be given the appropriate documents and asked to go to the NICRO center that is closest to you and to register for the course. The rest is simple. Attend the course and go back to court on the next date to hand them your completion certificate and completion report. Remember to take both the certificate, which is the one-page certificate, and the actual completion report, which is made up of several pages. The court will want to see both before the state withdraws the case against you. If you have successfully completed the course and you hand in your completion certificate and report, then the state will withdraw the charges against you and you will be free to go with no criminal record to worry about. And you can go home and sleep easy in your bed. If earlier in the proceedings representations were unsuccessful, then you will likely have to proceed to trial. But there's not much to be said about that in this video, as again, each matter will be considered on their own merits and your attorney will advise you on how best to proceed. I also just want to say that not all cases will be handled in this way, and this is by no means the only way in which to handle these cases. This is simply my experience as an attorney, having represented many clients that have been arrested for speed. And following this method, the criminal cases have been withdrawn against all of my clients. I have not yet had a client that was arrested for the offense of exceeding the speed limit and then subsequently convicted of that offense. So in short, what to do if you're arrested for speeding in South Africa? Remain calm. Confirm that you are being arrested, what offense you're being arrested for, what police station you're being taken to, and ask to speak to your attorney or family member that can call your attorney. Upon arriving at the police station, go through the motions of being formally processed and have your attorney apply for police bail. Upon appearing in court, allow the state to finalize their investigations, then obtain a copy of the state's docket. Consider the evidence in the docket and decide on how to make representations to the prosecuting authority on whether to withdraw the matter or refer the matter to a diversion program. If the matter is referred to a diversion program, go through the program, do what needs to be done, and obtain a completion report and certificate. Hand the completion report and certificate on the next occasion to the prosecutor, and if everything is in order, the criminal charges will be withdrawn against you. If, for whatever reason, representations were unsuccessful, then proceed to trial and argue your case there. Thank you so much for watching that video on what to do if you're arrested for speeding in South Africa. If you enjoyed the video, please like it and share it with a friend. And if you want to see more videos on South African law and the South African legal process, follow us for more. Remember that Roets Attorneys Incorporated is a general law practice that deals with all kinds of legal matters. So if you are arrested for speeding or arrested and charged with any other offense, or if you have any other issue of a legal nature, feel free to contact us on the details which are in the description below. My name is Ethan Roets from Roets Attorneys Incorporated. Thanks for watching and have a great day.